Sahaj Vidhi www.sahajvidhi.in Question 1. Explain the principles of most favored nation and a national treatment in the international trade law. Is it permissible for a WTO member state to impose different rates of reciprocal tariffs on other member states of WTO? Can a member state affected by the higher tariffs file a complaint with the dispute settlement body of the WTO? Discuss. Model answer. Principles of most favored nation, MFN, and national treatment. These two principles are cornerstones of the World Trade Organization, WTO, system, designed to ensure non-discrimination in international trade. 1. A most favored nation, MFN, principle, GATT Article 1 explanation. The MFN principle dictates that any advantage, favor, privilege, or immunity granted by a WTO member to any product originating in or destined for any other country shall be accorded immediately and unconditionally to the like product originating in or destined for the territories of all other WTO members. In simpler terms, if a country grants a special trade concession, like a lower tariff rate, to one trading partner, it must extend that same concession to all other WTO members. It ensures non-discrimination among trade, so create a level playing field and prevent countries from playing favorites, thereby promoting global trade liberalization and reducing trade barriers uniformly. Exceptions. While fundamental, MFN has some exceptions, such as customs unions and free trade areas, where members grant preferential treatment to each other, and special provisions for developing countries. E.G. Generalized system of preferences. 2. National treatment principle, GATT Article 3 explanation. The national treatment principle requires that imported and locally produced goods be treated equally at least after the foreign goods have entered the domestic market. It prohibits internal taxes and regulations that discriminate against imports in favor of domestic products. This means that once imported goods have cleared customs and any applicable tariffs, they should not be subjected to internal taxes, laws, or regulations that are more burdensome than those applied to domestic to prevent countries from using domestic measures, like internal taxes, regulations, or procurement policies, as a form of protectionism, thereby nullifying the benefits of tariff reductions achieved through negotiations. Scope applies to internal taxes and other internal charges, and laws, regulations, and requirements affecting the internal sale, offering for sale, purchase, transportation, distribution, or use of products. Permissibility of imposing different rates of reciprocal tariffs on other WTO member paid product purpose states. Generally, it is not permissible for a WTO member state to impose different rates of tariffs on alike products from other WTO member states. This is a direct violation of the most favored nation, MFN, principle. GATT Article 1. The MFN principle requires that any tariff concession granted to one WTO member must be extended immediately and unconditionally to all other WTO members. Therefore, if a country applies a 5% tariff on cars from country A, it must also apply a 5% tariff on cars from country B, country C, and all other WTO members, assuming the cars are like products. Reciprocal tariffs where one country imposes a tariff on another, and the second country responds with a similar tariff, are generally inconsistent with MFN unless they fall under specific WTO-sanctioned exceptions or are authorized as retaliatory measures by the WTO dispute settlement body, DSB, after a finding of a violation. For instance, if two countries form a free trade agreement, FTA, or a customs union, can grant preferential tariffs to each other, but these are specific exceptions to the MFN rule, requiring notification to the WTO. Can a member state affected by higher tariffs file a complaint with the dispute settlement body, DSB, of the WTO? Yes, absolutely. If a WTO member state believes that another member state is imposing tariffs that violate its WTO obligations, E.G., by applying higher tariffs than its bound rates, or by discriminating against its products in violation of MFN, it has the right to file a complaint with the dispute settlement body, DSB, of the WTO. The WTO dispute settlement process. 1. Consultations. The first step is for the complaining and responding parties to engage in consultations to try and resolve the dispute amicably. 2. Panel establishment. If consultations fail, the complaining party can request the establishment of a panel of experts to hear the case. 3. Panel report. The panel examines the evidence and arguments, and issues a report with findings and recommendations, for appellate body review. either party can appeal the panel's legal findings to the appellate body. 5. Adoption of report. The DSB adopts the panel and the appellate body reports, making them legally binding. 6. Implementation. The losing party is expected to implement the recommendations, typically by bringing its measures into conformity with WTO rules. 7. Retaliation. If the losing party fails to implement the recommendations, the complaining party may be authorized by the DSB to impose retaliatory measures, e.g., higher tariffs on the non-complying country's exports up to a certain value, as compensation for the harm suffered. The DSB is a central and powerful mechanism of the WTO, ensuring that members adhere to their commitments and providing a means for resolving trade disputes in a rules-based no-they manner. Please visit our website www.sahajvidhi.in for more content.